All right, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. And today's guest is a very distinguished and actually won last year the 2020 William Simpson Distinguished Paralegal Award. But regardless of the awards, very distinguished paralegal, with a couple of decades of experience, especially when we're going to talk quite a bit about small claims court, but as well, I think a lot about being a bencher and the paralegal standing committee. And certainly there's been a lot of exciting opportunities and things that have progressed. Probably you can share with us from how it was back in the days to where we've come today, and certainly where we can go in the future with paralegal scope and paralegal education. So thank you so much, Michelle Haigh, for joining us here today.
Oh, thanks for having me.
So Michelle, maybe you could start by sharing a bit about that lengthy background that you have here as a paralegal, and tell us a little bit more about your practice and kind of the evolution of paralegals and over your time as a paralegal.
Yeah, for sure. I'm actually proud to say that come this November, I'll have been in the business 25 years. I have been operating under Precision Paralegal Services since my entry into this profession back in 1996. I was a graduate of Sheridan College at the time, which was at that time the only college providing a program to teach people to be a court agent, which is what we called them back in the day. We didn't really become paralegals until regulation. There was some reference to paralegals, but most people went by court agent. So my career has really basically been around small claims, like you mentioned, and it's kind of progressed over the years. I was just by myself in the beginning, and I was doing small claims court, landlord-tenant, provincial offenses to start, and that quickly became focused on small claims court. I immediately found out I did not like POA. There's people cut out for that. It's not my forte. I did not enjoy it at all. I stuck with small claims and landlord tenant for a bit. Eventually landlord tenant kind of went by the wayside and I focused on small claims. And I think that's been part of my success, is that I was able to focus and really learn the process, procedures, and law, and all the different things you do in small claims. About 10 years into my career, I had met quite a good group of paralegals and court agents, and we had this great kind of a network that we relied on each other. We were all self-employed. None of us had employees at the time, and that's when I got into with the Law Society and regulation. I spoke at Queen's Park. I was one of the few paralegals that were in favor of regulation. We had a lot of bad apples. At the time, a lot of disbarred lawyers were acting as paralegals and generally bringing the profession's name down. Plus, there was no protection for the public. So I was in favor of regulation. And as a result of that, I was asked to apply to be on the standing committee in the very beginning. So in 2006, I was appointed by the Attorney General to sit on the paralegal standing committee at the Law Society. And we basically created the process and the bylaws, the ethics, and all that surrounding everything that created what regulation is today. And then I was able to stay on as a bencher for 12 years and really enjoyed my time there, but it was a lot of work. And like you had mentioned, big changes from 2006 to when I left as a bencher in 2019. All good, all progressive, all for the positive, I think. I mean, we're moving slowly in some areas and quicker in others. But yeah, that brings me here. And during that time, I was, became a mom. I've had to do that. I've grown my business. I think I now have 15 paralegals working for me. And my firm generally still, I would say now 60% small claims. The balance is landlord tenant. I still don't personally do landlord tenant, but paralegals in my firm do. I expanded into Alberta, and now we're a team of 4 in Alberta. In Alberta, just so you know, it's kind of like Ontario was prior to regulation. So prior to 2008, when anyone could just go in and be a court agent and represent someone in small claims, that's how it is in Alberta still to this day. Hopefully the changes will happen here too, and they'll talk about regulation. I know they've talked about it. I don't think they're moving very quickly on it though. So that's kind of me in a nutshell.
There's a lot in there, but I mean, I know you just ended with the Alberta thing, and I know I've had I had a lawyer and a paralegal from a firm out there that were kind of talking about it, but I didn't kind of realize it was there was a lot more open for you to do. So what kind of pushed you out to Alberta? I mean, it seems kind of I don't know if it came out of the pandemic as well, but perhaps you could tell us a little bit about it and what kind of things you can do out there that is not subject to any like regulation by like the
Right.
Law Society of Alberta?
For sure. So actually, I opened the firm here in 2016, but we did it more. We had some corporate clients, and they had a need to assist with small claims court matters in Alberta. So it was our corporate clients that kind of had us think about it and eventually open up here. We did it mostly remotely for the first couple of years. And we had people on the ground who would file the paperwork and so forth for us, do the service of documents. And I would fly out to attend court when necessary, which wasn't very often. Most things here settle, or, well, small claims generally, a lot of things settle. And our volume wasn't too terribly big. But you're right about the pandemic. When the pandemic hit and Ontario courts basically came to a screeching halt and shut down, and we didn't have a hearing for like 6 months or more, you can imagine how that affects your business. 80% of our billings were court attendances or preparing for court attendances. So we were, hit hard with the pandemic in Ontario, but in Alberta, the courts didn't really close. They closed for 75 days and that was it. And then they opened right back up. I've been in a courtroom in Alberta. I was in the courtroom like 6 months ago in Alberta. So and we're still not in a courtroom in Ontario yet, which is fine. Don't get me wrong. I like doing things by video, so I'm not going to really complain about that. But we had an opportunity when nothing was happening in Ontario that we really focused on our business in Alberta. So I've been in and out of Alberta throughout the entire pandemic, and we've hired 2 people. So we went from a team of 2 to a team of 4 fairly quickly in Alberta because of the pandemic and the focus we put on out here. But in Alberta, you can do anything where the legislation says an agent can act on your behalf, or you can be represented by an agent. Now, like Ontario, people are taking that maybe a step too far out here. You may have seen in the news today on Go Public by CBC, there was an article that was released in an interview with a gentleman who hired a paralegal in Alberta to do his divorce. He did the divorce, took the money for it. A year later, the guy finds out he's still married, and he was told it was all wrapped up. So these are the types of things that were happening in Ontario, which caused regulation to happen. And now it's hitting the news out here like it used to in Ontario prior to 2008. So maybe this will push the Law Society or the government to, reconsider regulating court agents out here. But, we'll see. Right. So now people are doing wills, people are doing family law. I'm really still sticking to my preference is to operate in areas that I'm allowed to in Ontario. If I can do it in Ontario, I'll do it in Alberta. I'm not going to go outside that scope. I still have a regulator in Ontario. So if I screw something up out here on a matter outside of my scope in Ontario, I feel probably not it's not good for my reputation. So I'll stick to what I know. But people are doing all kinds of things out here. But, and the regular stuff that we do in Ontario too.
Well, so I mean, that might be an interesting thing to kind of look at, because you have the perspective of pre-regulation in Ontario, and I know even BC and some other places in Canada are looking at, well, can we do more? I mean, in terms of, the number one reason really access to justice, right? I mean, in terms of providing more educated, right? I mean, certainly before there was no education, but more educated, experienced people at a fraction of the price that maybe lawyers would be charging, right? So you're looking at kind of providing greater access to justice. But again, as you mentioned, well, there has to be that competence piece too, right? I mean, if anyone, I know, for example, like the immigration consultants had that same kind of issue as well before regulation, that someone's saying, hey, yeah, I can get you sponsored, and they weren't doing anything, right?
That's right. Yeah. Yeah. So go ahead.
I was just going to say, so what do you think in terms of how you've seen that change? And is that something that we can look at in the rest of Canada as well?
Yeah. So that's been my focus. So my last couple of years with the Law Society as a venture, that was my focus. That's what I was kind of to push. I was always invited to the Federation of Law Society meetings where all the law societies would get together every fall. I would be going to those events and meeting all the other provinces and territories and their law societies, and talking to them about paralegal regulation and how it's worked in Ontario, and how it doesn't necessarily have to be identical in every province or territory, but it's definitely something that they need to consider. I mean, public protection is the number one reason why. I mean, that's the law society's mandate. First and foremost is public protection. So if you have someone playing in that field, the legal field, you should be aware of it at very least, right? But lawyers aren't the only option, clearly. You can become educated, very educated, and specialize in a certain area of law and focus on that. I have a lot of lawyers who refer work to me, not just in Ontario, but in Alberta too. And I just think it's, I think regulation is important. I think some law societies are doing it because the members, the lawyers, don't want it to happen. But in Alberta, in response to that Go Public article today, the government says, oh, we don't want to regulate because there's cost to regulation and it will just increase the paralegals' fees and then they won't be affordable anymore. Well, we've seen in Ontario that that's not true. Paralegals are still very affordable and still generally a third the cost of a lawyer, from what I can see. I mean, there's different ranges, of course, but I have paralegals in my firm that charge anywhere from 95 to 195 an hour. So, depending on the complexity of your case will depend on the paralegal you need. But, and then you come to traffic tickets. I mean, it's so much cheaper to retain a paralegal that why would you ever retain a lawyer for something like that? And public protection is just number one, right? And that's where the articles will hit the newspaper and the news is when someone's taken advantage of. I mean, lawyers do it too. The difference is the lawyer takes a client's money. There's a compensation fund that the client can go to and get their money back. So if you were not regulated, that's not available to the public.
Yeah, I think generally your option would be to sue in small claims court or superior court, depending on the amount and the time period for that. I mean, it's not going to really provide enough of a remedy for what you may have lost, depending on the legal situation there, right? Whereas, I mean, you also have the ability with a complaint to a law society to potentially remove that person from practice, or at least put significant restrictions on them, or education accreditation, things like that you wouldn't have without regulation.
Yeah, and the simple things like just sometimes there's, sometimes people make a mistake, right? Paralegals, you'll likely make a mistake at some point in your career. Lawyers do too. That's why they're insured. That's why paralegals are insured in Ontario, required to be insured, just because sometimes you miss a limitation period and, stuff happens. So it can happen. And the knowing that if you're regulated, you have to have the insurance, you're, again, public protection, right? So when I'm in Alberta, I have insurance here too, even though technically I'm not required to have it. I think it's very important to make sure that the public is protected. And it's part of our sales pitch too, to be honest.
Now, in the sort of 12 years that you were, or even more really, in terms of involved with the role as a bencher there, as well as the paralegal standing committee, what changes? I mean, I know some of them are still continuing on today, like with family law. I mean, I don't know since really November of last year what's happened, but what have you seen there, and what are you most proud of in terms of providing into the profession some more opportunities? And what do you think the direction in Ontario, at least, is going to go with some of those areas that kind of remain on the fringes, or depending on, some of the, there's litigation on some of them as well happening, but where do you see kind of the future for the scope for paralegals?
Yeah, so as far as the scope for paralegals, I mean, I do really think that the family law will come through one day. It's not something that's happening obviously very quickly. I had worked on it for 2 or 3 years before I even left. So it's been in the works for like 4 or 5 years. It's, going crazy slow, but then there was a big change in the benchers. So there was an election. The year that I left is the year that the board pretty much completely changed. So it's almost like starting from scratch again. It's just like any government body, right? You bring in a new party and there's going to be like lots of changes and they want to take different direction and so forth. So that has definitely put a delay on it. I think hopefully we'll see some more movement in the next year. Also, the pandemic slowed things down. There was different priorities over the last year. I mean, that's changed for everybody. When I was there, and it hasn't really changed its scope of practice, but a couple of key changes that happened while I was a bencher, which I'm very proud of, is one, when I first became a bencher, became a part of the paralegal standing committee, there's only 2 of the 5 paralegals on the committee that were benchers. So only 2 paralegal benchers were in convocation against like 50 odd lawyers and lay members. And the other 3, me included, weren't allowed to go to convocation, which is where the board makes all the decisions. So it was really frustrating that we had 2 voices against all those others, and 3 of us who had, some good stuff to say weren't invited to the table. We were basically confined to the paralegal standing committee. And then we had the Morris report come out. And one of the things I pushed through that whole process was we need more voices at the table. Like there's no reason why we should be three of us just members of a committee and not part of convocation. So very quickly after that, we were able to pass on the Morris Report's recommendation to make sure that all 5 members of the Paralegal Standing Committee, all 5 paralegals, were benchers at convocation, which has made a big difference in the end, to have those 5 voices and now all mingling with the lawyers and creating those relationships and helping change happen. So that was one good thing. Another good thing is that we had a lot of exemptions in the beginning. So when we first regulated paralegals, there was a lot of groups of people that were exempted from having to get a license. So if you were, and I might get the terms wrong, but if you were a legal support worker with legal aid, like working in a legal aid clinic, so basically you were acting as a court agent in legal aid, you didn't have to get licensed. If you were a prosecutor for a municipality or province, you didn't have to be licensed. If you were part of the human resources group, and I can't even remember, advisory, I'm not even sure what it's called, but there was a whole bunch of people who were not required to be regulated. So a lot over the years, we've taken a lot of those exemptions away, requiring those groups of people now to be licensed as a paralegal. And the great thing is the ones where we haven't really changed, like the prosecutors, we have not taken that exemption away. However, you very rarely now will you see a municipality or the province hire anyone other than a licensed paralegal. So despite the fact that we haven't taken the exemption away, there's been a change and their hiring practices have changed. And same with legal aid clinics. Rarely do you see them just hire an individual and train them to be a legal support worker. They're hiring paralegals now. There's a benefit. I mean, they're specialized in, especially with legal aid, paralegals are specialized in helping everyday people with everyday problems. You're more likely to go to traffic court and small claims court than you are to criminal court. So, you have a specialized group of people who can help assist in these everyday things, landlord-tenant matters especially. So those are all access to justice issues, and people are trained to do it. And legal aid, they're always on a limited budget. So it's cheaper to hire a paralegal than it is a lawyer. So there's some good changes happening.
Yeah, and I think there were some recent exemptions. They've expanded very recently, like maybe like the last convocation meeting.
I think so
as well. I remember hearing that. Now, other thing I wanted to talk to you about, you just mentioned you had 16 paralegals working for you, which is very similar to kind of a traditional law firm kind of structure. That's very rare for paralegals practicing. I mean, I can't really think, maybe you might know of a few others that have that large of a staff. So how do you find in terms of having 16 different paralegals working for you, in terms of having, from where you started, I mean, presumably on your own 25 years ago to where you are now with that growth, how do you find managing and I mean, maybe taking more hands off in terms of a lot of the landlord tenant practice essentially is done by everyone else. How do you find that in terms of managing that?
Difficult at times. But I think it's like any business, as you expand and you have more personnel and more staff and more clients, more issues come up, right? So not only am I managing more client issues, I'm managing more HR type issues. I did this in hoping to be more hands-off on the day-to-day client stuff, and that's not happening. I still have a ton of my own clients. I can't seem to say no. Don't get me wrong. I mean, it's difficult. It's challenging. I love what I do. I wouldn't change it for the world. But yeah, it is definitely more of a challenge of managing others than it is just managing yourself, manage your client expectations. So it's been a challenge that way. But what I like about it is I have everyone from, like, say, a brand new graduate. Sometimes we hire our co-op because they knock it out of the park and we think, oh, this person's gonna be fantastic. We'll keep them on, we'll train them. There's a number of my employees that started as co-op students. Actually, they're both in management now too, which is fantastic. So we have that aspect. So I like hiring new graduates, new licensees. And I also like hiring those. It seems to be one or the other. It's either the new licensees or the ones who are kind of more end of career, trying to figure out how to transition out. So 5-6 years before retirement, they want to join a firm like mine. We help take the load off. They don't have to run their own business anymore. They can focus on clients and, take some time to themselves. And then slowly when they're ready, they can start to transition out without having to worry about winding down a practice or anything like that. So that's who I seem to attract as far as paralegals, which I love, because Then we have that group of paralegals who are very well seasoned and so forth, and they act as mentors for the newer paralegals. And it's such a great trade-off. And we have this chat on WhatsApp, and they're always talking back and forth, throwing out legal questions or a problem that they're having with a file, and everyone's piping in. And it's just a great community. And that's what I love most about having a firm, is being able to lean on each other. Being self-employed was extremely difficult. You want to take vacation, well, you couldn't. You could go to Mexico, but you'd have your laptop open on the beach. Like, you just can't get away. But if you're working with someone else, it's easier to say, can you just, have my back for a week while I try and get away and decompress? And that way, it's a much better situation to be in.
See, one of my students kind of wanted to follow up about the new graduates, because I think, one, it's rare that there's so many people being hired at a firm to begin with, but two, then that there's a lot of opportunities for people who are on their placement or co-op, and then they turn on and continue on. So how have you found that, since you've mentioned a few of them have made that transition, how's that worked for you with bringing in the new graduates, and why should others look at potentially bringing in brand new, fresh out of paralegal school after they get their license, new licensees onto their firms?
I think they bring a new perspective. I like bringing in new people, especially new licensees. And that doesn't necessarily mean a younger person. That just means new licensee. So they could be one of two people. They could be fairly new into building a career. They're in their younger years and just trying to get started. They bring a great perspective of how our clients want to be served and so forth, which always helps us adapt. But then you also get the new licensees who, this might be their third career. So they bring a whole set of different skills to the table. And then sometimes we learn from them because they've had experiences in other professions, and which helps us guide our, change our processes or marketing or whatever. I think that everyone has something to bring to the table, and sometimes it's their legal knowledge, but sometimes it's not. Sometimes it's something else, and it really helps us have our firm progress. I don't want to stand still. I don't want to get stagnant. I don't want to become irrelevant. We're constantly trying new things in our firm: technology services, do-it-yourself assistance, coaching, claim reviews for people. So we're trying to do all kinds of things to make sure that we hit all the marks on what the public needs right now.
Yeah, that's great, because certainly there's a lot of diverse needs, and certainly the unbundling of legal services and things like that someone might just want you to look over something very quickly, rather than have you on for the entire, or they can't maybe afford you for the entire matter. But
right,
we're seeing more of that. And again, talking to what we were mentioning before about access to justice, what are some other things that you've mentioned a few things, what are some other innovative ways, with technology as well, that your firm has been looking at doing things differently now than?
Yeah, we've during the pandemic, we launched a product called Claim Easy. So it's claim, CLAIMEZ.com. And that is basically something where someone can do it themselves, a small claims court claim. So pretty much it walks them. So for $75, it walks you through the process, asks you questions, tells you exactly what needs to go in certain slots, walks you through it. That could be it. Then you can just send it to us. We'll issue it for you, and then we send it back to you for service. The other options, then there's a series of options. So if any of your students want to go look at the website, there's different options where you can also have a legal review. You can have a legal phone call, and you're paying just for that specific service. So there's been times where I've reviewed a claim where I see they're suing Joe's Garage. What I'll say to them is that you really need to be doing a business name search or a corporate search on this company. I doubt it's actually called Joe's Garage. If you sue in the wrong name, your judgment is not worth the paper it's written on, right? So I walk them through what they need to do to make sure that their claim's successful before they file it, because we all know amendments and everything take time, and it's frustrating, and people will often walk away from it because they just don't understand, some of the technicalities. Or sometimes we really realize that, hey, you've got a really complicated claim here. This is an employment matter. You might want to speak to somebody about it. And so we can make those recommendations and so forth. Another thing we've done is offer 15 minutes of legal advice for $40. Most of those are done in less than 15 minutes. And the reason being is they usually call us with a very specific question. maybe it's a better limitation period. And we can't always give them the answers, but we can, give them saying, well, you need to be looking at this, this, and this. You may need another hour of someone's time to do some research for you. And then we quote on that and so forth. And then they get what they need, but they're not overpaying right at the start. So there's things like that we've been offering. Demandletters.ca is another service we kind of launched. I think that launched slightly before the pandemic though. But it's getting used. I mean, it just helps people draft these letters, or they can purchase a demand letter to be written by a paralegal if they choose to. So, it's all these different array of options, but it's the way things are going, right? People want to do it themselves.
I think maybe for my students here, and I know I have a group of students who are just about to start small claims court next week. And then I have a group of students who are working on a small claims mock trial next week. So they're kind of at different stages. Ones are almost done and ones are about halfway through the program. So, I mean, you mentioned, the Claims Easy there, right? In terms of maybe we can look at walking a claim through, right? If someone comes in, whether they're using that service or certainly more traditionally, they're coming and they say, Michelle, hey, I have this problem. Probably something like I do some plumbing work, and my clients there don't want to pay the rest of the amount, even though I finished the work, which I think is probably the most common, one of the most common issues. So how do you kind of guide them through the process from now? Obviously, first step is getting all the information and then issuing the claim, and all the way through to trial. So maybe we can break it up segment by segment.
Yeah, but when they first call, honestly, there's some key questions we want to ask. When we go, first of all, we want to say, so if you're a plumber, let's use that example. How much is your bill for, right? If it's like under $5,000, you're probably not going to want to retain us on a full retainer. So how do we help you out the best I can? And sometimes just talking to them, I can figure out, hey, you might want us just to do your pleadings for you to make sure that they're done properly. One of the most important parts of the process is to make sure your pleadings are correct and you're pleading all the right things. So we can just do that for them. Or if we, it's a simple unpaid invoice and they can draft the claim themselves, but they're just terrified and don't want to go into a courtroom. We can say, well, draft your claim. It's an unpaid invoice, pretty straightforward. We can kind of give them some ideas of how to draft that, get it issued, get it served. And then when you get your settlement conference date, call us back. And then we can help you with that process, because, pay for what you need, right? Sometimes the full retainers, and I find that the paralegals have been around a long time, or were grandparented into the profession in 2008. They're less likely to do an unbundled service package than the newer paralegals. And I'm not sure why that is. Maybe that's just kind of where the needs are right now with the public. But, I really strive to make sure, but hey, say it's a $20,000 plumbing bill, and we know there's going to be a defense and a defendant's claim filed. Well, then they're probably going to want to put us on a full retainer to manage that whole process, right? Make sure things done properly from the beginning. So key question in the beginning is, how much is it for? Do you anticipate a defense? Are they complaining about something? Like, can you give us a heads up? Two, where is the property that you did the work at? Like, are you looking for someone to represent you in Ottawa, Toronto, Sarnia? Right now during the pandemic, it doesn't matter because everything's being done virtually. So we can represent anyone anywhere in Ontario right now, which we've always done, but we've also had a group of paralegals all over where we would contract out to attend certain hearings when we couldn't do it by phone or by video. But when it comes to a trial, if it's going to go there, and I would say less than 10% of my matters actually go to trial, most of them can be settled or resolved. You kind of have to physically be there. So where it is important. And you got to know you can serve them, because if you have a claim against somebody, you have their name, but you can't serve it, it's no good. You got to be able to serve it. So those are kind of the key questions we ask. And actually, before we even wrap that up, one of the key questions I've tried to instill in my paralegals all through everything is like, okay, so we do all this, we get you your judgment. Sometimes I say that's the easy part. Can we collect it? Collection of a judgment is where most paralegals, most lawyers fall flat. They get the judgment, they think their job is done. Well, to me, you're just starting. If you don't get your client's money back, you haven't done them any service.
Yeah, and anyhow, that means you basically have thrown good money chasing after bad money. I
Yeah.
mean, the lawyer, the paralegal is benefiting from their fee there, but
Yeah.
the client's actually in worse of a situation because now they have less money that they've paid out and they still can't collect it. So they're
Yeah.
better
And
off
that's
doing
it's
nothing.
a serious conversation I have all the time with my clients. And I tell them, like, listen, first of all, yeah, I use those exact words. Don't be throwing your good money after the bad. Like, it's like, are we going to be able to collect this? Now, if it's a plumber or renovation, likely they're homeowners. So, key, like, okay, homeowners, that's a good thing. They're likely working. They're probably paying a mortgage. Chance of collection is higher. You loan money to a deadbeat friend who's been on, EI for the last 6 months and has no intention of getting a job. Might be a little harder to collect from them, or they always work cash jobs or something, so you can't garnish. We try to have those conversations up front so they're not spending the money, and before they have to.
Now, one of the things there, I mean, I was trying to work in a little ethics because one day, maybe I can write to the law side and get some accreditation for the CPDs and stuff like that. But because you bring up a lot of the unbundled services, and certainly there's obviously the danger that, hey, you help them out with a couple of phone calls or even like a 15-minute call, and now they think Michelle's going to be doing everything for us for $40. So how do
Yeah.
you kind of explain to them, hey, I'm only doing this service, and make it very clear that that's the end of our retainer?
Yeah. So a couple things. One is your disclaimers and your retainer and kind of the conditions of that phone call. So when you book a 15-minute appointment, there's all these, we talk about, like, they get a notice of exactly what's involved, what's happening. Doing we always follow it up with an email after. So in order for them to book the consult, we have to have their email address. So we will take that email address at the end of the call and send them off an email saying, this is what we discussed. This is what we suggested. That is the end of our retainer. If you need us in the future, feel free to reach out to us and we can talk about additional services. So those are two key points. One, let them know in the beginning before you talk to them what the limits of the retainer are. And two, at the end, let them know it's over. Now it's over. And when you're doing a limited scope retainer, so you're just preparing pleadings or just attending a specific hearing for a client, it's the same deal. Like, make sure it's extremely specific in your retainer, what you're doing, how much it's going to cost them, and that'll be the end of the retainer. And then once you're done that, make sure you send that closing letter saying, I've done what I'm supposed to do. Thank you. If you need me in the future, let me know.
So let's move on to the next stage. And I know some of my students have a mock little settlement conference this week as well. So next big stage there, as you point out, is, okay, once we've gone to the pleadings, they file their defense, and we're moving on to settlement conference. How do you approach settlement conference? And I know one of the common mistakes I do see with my students is that they approach settlement conference like it's a trial, and they put on all the glamour there, and think it's like an episode of Suits or something. But
Yeah.
what can you share with them about best strategies with settlement conferences? And again, it certainly depends on if there's representation on the other side or if they're self-represented.
Big difference. First of all, I want to make sure that I have that good conversation with my client prior to the day of settlement conference. Not only do I talk to them like before the day of, right before the settlement conference, I want to make sure a week or two in advance of that, I speak with them. Gives them time to think things over, because I want them to come to settlement conference with an idea of what they would be willing to settle for. So you got to have that. You can't have that conversation 15 minutes before settlement conference, because they're like, okay, and then they might, make a hasty decision, and that's not good for anybody. So a week or two before, I'll make sure I have that conversation with the client. I explain to them what the process is, what a settlement conference is meant for. We do a disclosure and a witness list prior to, and we also receive disclosure before the settlement conference. So you want to make sure you go over that with your client and kind of point out any issues you might see. So you want to have a good understanding of the case going into a settlement conference, but you also have to let your client know, and the hardest part is managing your client most of the time. Let them know, listen, we're not going to be getting into detail after detail after detail in a settlement conference. A judge wants the high level points. What is the claim about? What's the defense? Let's narrow the issues. So if you can narrow them before you even get into that settlement conference, that's great. So sometimes it's, oh no, I agree that I'm, like, say I represent the defendant. We agree he made a mistake, and that, liability, yeah, absolutely, we agree liability, but we don't agree with the quantum. They're claiming 25,000. We believe quantum at most is 2,000. right? So now we've just narrowed the issues. So the plaintiff does not have to prove liability against the defendant. Defendant doesn't have to respond to that. All they have to talk about is, why are you at 25,000 and why is the defendant at 2? And then you can kind of narrow things down that way, right? And then you can also speed up the trial for your client when you narrow those issues. And it's a lot less costly for everybody. Sometimes people just won't admit anything, and which is fine too. I mean, that's a strategy as well. Sometimes, liability might be hard to prove. So why would you admit it? Sometimes it's just plain and obvious. So you might as well admit it, right? And move things along. So managing the client's expectations, they're like, well, why didn't you talk about that letter? Or why didn't you talk about that email? Or what about on this date? I'm like, we don't do this at a settlement conference. It's not what the purpose of a settlement conference is. And in fact, I find the more details and back and forth you talk about the issues between the party and where they're different, the less likely you are to get to a settlement. So, because you're just going to get their backs up, right? And then they'll just say, oh, I was willing to settle for 5,000, but now that he said that, forget it. I'm not going to settle now, right? So, it's managing your client, making sure that they understand the process. I don't like to go, well, we don't want to pay 500 for that or 300 for that or whatever. So, we're willing to pay 2,000. You just want to kind of, what are you willing to take? Let's get some numbers on the table and let's not talk about the facts because we're never going to agree on the facts. That's why we're here. Right. So that's some of the strategies I use. Every file is different. You're going to take a different strategy on every file, but know that your client needs to know is no witnesses. You're not going to get into great details. You're not going over the evidence. The settlement conference judge does not care about that.
And you mentioned certainly about sometimes the dollar amounts are so close, but you have clients either on either end or both that are like, oh, well, I'm not going to budge. I've reached my point of, my resistance point here. That extra $500, no. But I mean, they're going to end up spending way more than that. Should it go to trial? How do you kind of convince those principal clients, or even this goes back at the beginning where you were saying, well, hey, it's only a $900 issue here that of your bill that's not paid. By the end of it, you're going to have such a larger amount that you're going to pay out of it. How do you kind of get through to them and explain that? Like sometimes your principals have to come at a cost benefit analysis here.
Right. And it's a frank discussions. I basically approach it like you just did. I say, okay, well, let's look at this. We could walk out of this today if you just give up another $500, whether they're paying it or reducing a settlement by 500, it's $500. Like, what are you doing? Like $500 won't even get you prepared for trial. Never mind attending a trial. So I'll talk to them about all the fees, the likelihood of collection again will come up. Like, so if you're the one accepting a payment, someone agreeing to pay is going to be a lot easier to collect than someone you've got a judgment against and now have to chase. So it's more money in your pocket now. And then we also talk about the likelihood of what kind of cost recovery you're going to get at the end of a trial. Like the first conversation I have, like when they're hiring me, is that, listen, you might get some of my costs back. You will never recover all your legal fees, ever, ever. It's just not going to happen. And we can get some pretty sizable cost orders, but those are usually on really complex matters that have gone 2 or 3 days in trial. Well, you still spent a lot more than that, than what the cost order is. So you're going to always lose money at the end of the day. How much are you willing to lose? And then when someone says to me, and they'll inevitably say, it's the principle of it. I hear that every day. I'm like, well, I'll tell you right now, what that has shown me in my 25 years of practice. Your principles will make me a lot of money and lose you a lot of money. So just so you know, I'm okay. If you want to push your principles, I'm in, because at the end of the day, you're paying me, but I don't think it's wise. And I'll explain to them why and what the risks are going to trial. And as much as we think we have a great case, we get the wrong judge on the wrong day, they're going to take it completely different. We just can't predict the outcome of a trial. I've lost trials I thought I would win, and I've won trials I thought I'd lose, and I am done trying to predict the outcome.
That's great. I mean, I think certainly the biggest thing there with litigation, as you pointed out, is the uncertainty. I mean, there's no guarantee one way or the other, or even if it's on your side, the dollar amount that they're going to award to your client, if you're the plaintiff, is going to be what you were expecting or what you may be getting. And then the whole cost considerations may come into play as well with offers to settle. Now, one other thing there with settlement conference that a couple of people who have been on before, they kind of had different, or I don't know what your take is on it, is if you have a real, and I guess probably every case it depends as well, but if you have really good either law or facts on your side, do you kind of bring that all onto the table at settlement conference in the efforts to spur a resolution, or is it kind of like, I don't know, like in poker or something, if you have pocket aces, you hold on to them and then you drop them off on trial and surprise the other side? What's
It's
kind
funny.
of,
It's a debate that we have in our firm all the time, and every file is different. So I can't say there's a right or wrong way. There's times to hold your cards close, and there's a time to lay them on the table. And it really depends on the situation, or how badly do you need to get this settled? Is your client? So I've had clients say, "I do not want to go to trial. You need to settle this, but I want this amount of money." So work your magic. So I'll do whatever I can. If that means throwing all my facts on the table to get it, I'll get it. Like, I'll do what I have to do. But sometimes it's very rare I hold all the facts close to my chest. I'm just not that person. It's not how I negotiate. But I have a couple paralegals in my firm that do it. But I'll tell you what they do is they make sure that their clients are aware in advance. First of all, you don't want them stating something in the settlement conference that you don't want them to say. But also you don't want them questioning later, why didn't you say this? Why didn't you do that? Right? So if you have a strategy, just make sure it's communicated with your client and you have their buy-in, because it's not going to work out very well for you. It's going to make you look like you forgot something or missed something. So they're going to need to know your strategy in advance. And the paralegals I do know that will hold some cards close to the chest at a settlement conference, they make sure that they have that conversation with the client.
that's a very important point too there, right? I think one of the number one complaints is a lack of communication from my paralegal or lawyer. So how do you kind of find that balance between making sure they know what the strategy is or what's going to happen versus the client that's going to call you and be like, Michelle, what are you doing right now? It's 9:45 in the evening. I'm waiting to hear back from you. You didn't respond to my email from 9:33.
Yeah. Yes, we have those clients. Client management is the hardest part of our job. And like you said, the number one complaint the law society gets is communication between, the legal practitioner and the client. Number one complaint, both sides of the coin, paralegals, lawyers. Now that I have a firm the size I do, the good thing is people come to management to complain and not to the law society, because there's somebody above the person they're dealing with. So we probably, stop a lot of unnecessary complaints to the law society on communication, and we have to step in. But still, that is the number one complaint I get. Managing a firm is, hey, so-and-so is not responding. So we try to, work with that and work with a paralegal. Sometimes it's, there's a lot of mental health issues these days, especially with the pandemic. We've had some paralegals that, kind of like turtled and just kind of lock themselves in a room and just say, I can't deal right now. Today's not a good day. And we try to support that as much as we can. Another great reason to work for our firm is you can have that support, right? So we just communicate with our staff too, saying, listen, you got a client is not going to be happy and you have kind of ignored them and it needs to be dealt with. Please bring it to our attention. Let someone else call them for you. Let's step in and let's try and smooth that over and get things back on track. Because sometimes it's not the client's issue, it's the paralegal's issue, and sometimes it's the other way around. But just those expectations. So we have to set out the expectations. When someone's hiring me, I'm extremely busy. So if they want something done tomorrow, I say, I'm not the person for you. There's no way I'm going to get that done tomorrow. I have at least I've got my next 2 weeks planned to the minute. So, if you want me to do it, you're going to have to wait and you get in line. And, if there's a limitation issue or something, I will drop something to get to it. But if it's nothing that's urgent, I just have to manage my client's expectations, saying this is where you fall right now. And I can, commit to getting it done by this date. And don't make it tomorrow or the next day if you know you can't do it, right? Put it out there. And if you get it done early, great. So it's managing client expectations is key and hard.
You don't want to overpromise and underdeliver, right?
Yeah,
so that's
happens a lot.
Now, I think I want to go on then to the last thing there. Obviously, there's some other stages and certainly the enforcement stages afterwards. But, students want to know kind of trial prep. Some people are like, feel like a deer in the headlights the first time, whether it's your first mock trial or it's your first actual trial. So in the rare instance, it makes it all the way through and you're now staring down opposing counsel who are vigorously and zealously defending their client there. You're saying, you know what, the reason why we didn't pay your plumber here is because they didn't do the job to the satisfactory standard. Or we can go with any scenario there.
Yeah,
but what in terms of advocacy tips there, I mean, that you have for students in terms of getting through that deer in the headlights moment and delivering at trial?
I'll tell you, the first trial, you'll never make money on it, first of all, because you're going to, if you're doing your job right, you're going to over prepare. And you can't bill for 100 hours of preparation on an unpaid invoice trial, but you're going to do it. You're going to spend it because, first of all, you're terrified. And second of all, you feel like you have to have all this research and all these, the case law and so forth. And sorry, I got my dog poking me in the background here. So sorry. She wants attention. But I remember my first trial, a lawyer had retained me. So this is going back like 1997, maybe. I did my first trial. And it was given to me by a lawyer. So they had done all the pleadings, everything had been done, settlement conference done. So I was coming in kind of last minute. So I'm preparing for my trial and everything. I drive to London Small Claims Court. And I swear to God, like I was so nervous. My voice was shaking through the entire thing. Like I felt so bad for my clients, like who the hell is this person representing us? Oh my God. And I was up against a lawyer who was like taking no prisoners. It was actually the most horrifying experience of my life. But at the end of the day, I won the trial and I had a sweet judge, and they're not all sweet, but I had a sweet judge at the end who said, "Ms. Haigh, you did a fantastic job." And I think he was just trying to get me to calm down. But it was an experience. But honestly, your first trial, first mock trial, first real trial, you can't be over prepared. You can't be. And if you are prepared, you're not going to be nervous. You're going to be nervous, but if a question comes out of the blue, you're going to be able to answer it. It's just, that is my biggest fear, is being in a trial situation and a judge asks me on a point of law or an issue that's been raised, and me looking like, I never even thought of that. I have no idea how to answer that question. That is the worst. So over preparing, and it happens in the beginning. You will get better at preparing for trials as you get more practice and you learn your style and you learn your techniques. Everyone's different. I can prepare for some trials now, in a couple of days, depending on the length of the trial or the complexity of it. But if you've done your job right all the way through, most of that's done for you, and you're more refreshing your memory on certain facts, rereading case law, getting a skeleton list of questions kind of put together, getting your witnesses prepared. I think a lot of people don't prepare their witnesses. It's one of the things I see the most, is they're asking questions of their own clients while they're on the stand, and clearly they didn't know what the client was going to say, because they're like, oh shit, shouldn't have asked that question. So preparing your client and knowing what your client's going to say, that's a big deal. Cross-examination, don't overcross, because if you don't know the answer to a question, you shouldn't be asking it. The cross-examination is probably the hardest thing. It's probably one of those things too that to this day I still say I'm not very good at. I'll opt out of it more than do it and mess something up, especially if things are going my way. I will avoid cross-examination, except for I'll always do like some key points, either clarification or something where I know they can't give the wrong answer because it's in black and white somewhere. But anyway, it's, trials are, they're not for everybody. I know a lot of paralegals who just don't do them. They'll do everything else, but then hire someone else to do the trial or something like that. So that, and that's fine too, as long as the client's okay with it. But if you're not going to be able to do a trial, make sure your client knows in advance, or let them know that you're going to have someone assist or something at least. But, some people too, I know a couple paralegals who have been in the profession 2 or 3 years before they'll even attempt their first trial. So, everyone's different. I also had someone that within their first 3 months, they did a trial and they rocked it. So everyone's different.
And Michelle, now you have the different practices in Alberta and Ontario with the different rules. I know Ontario is slowly coming, well, we're still not in person for trials though, but in small claims at least. So in terms of advocacy over Zoom versus in person, how have you found, you have that contrast, I think, really well right now with the differences there. How have you found the remote kind of motions and trials in Ontario versus, obviously versus before when they were in person, but in terms of Alberta, you said you were in the courtroom. How have you found the difference?
I like the virtual and I'll tell you why. Well, first of all, I think it's a lot less expensive for the clients. Okay. So you're not charging travel time and mileage and parking and all that kind of stuff. So it cuts the price almost in half. I used to travel an hour and a half to Toronto to do a 30-minute settlement conference, to drive an hour and a half back, and my client would be paying for me that time, right? Or even if it's a flat rate, you're incorporating all that time in there. So there's that. So for short hearings, assessment hearings, short motions, settlement conferences, I think they need to stay virtual. It just doesn't make sense to be traveling to all these different courts to do these hearings. So that's one thing. I've done a couple trials. So I've done a discipline hearing. I represented a paralegal in front of the Law Society Tribunal during the pandemic. It was all done by Zoom. So first trial I'd ever done by Zoom. It was so well organized. I mean, everyone had their documents in PDF format with bookmarks, and you can flip to a tab really easily and share your screen. And I found it extremely streamlined. I honestly, I liked it if the parties are prepared. I can imagine, though, some trials being an absolute horror show. You've got individuals who don't know how to do PDFs, or they're self-reps and don't know how to, properly scan documents. I don't know if you see, but a lot of clients will take photographs of contracts, page after page after page, and then you get them and you're like, I can't read this. Like, I can't deal with this. That's probably going to be the bigger problem, is the quality of the documents and after they've been scanned, as well as people just not being very tech savvy. Now, I think a lot of people are getting a lot better of it because of the pandemic, but you're still going to have individuals who are not comfortable with it. I have clients who are not comfortable with it. So either I get them into my office and we'll do a settlement conference by Zoom together in the same room, unless they're comfortable participating on their own from their own office or their own home. But we're also, just so your staff, your students should know, that I'm likely going to be putting on a Zoom webinar on how to do a trial via Zoom. So I'm doing that with the deputy judge and another paralegal, and we're going to do kind of like a mock scenario and show clips of how things are done and so forth. So your students might be interested in that. Usually they're free, or like $25. Like, it won't be expensive, but it'll be interesting to see the kind of feedback we get after that.
Perfect. I'll definitely be sure to reach out to you to get the information so I can share to everyone interested in. So I'll be getting a great perspective of having both sides there as well. I think the importance there is the technology that you mentioned. It makes or breaks a trial, because if you can't share your screen, and it just slows things to a crawl at like 10 times the amount of time to get through. If you have like 15 documents or something to share. Now, you did bring up mental health there, and certainly something with the pandemic really important. And you mentioned certainly with your firm, they're making sure that everyone's got the opportunity to address their own mental health, especially in our profession where all sorts of stressors and addiction and things like that. What have you kind of found that's worked for you? I mean, I saw your dog there, so I mean, perhaps
he helps. Works for me. So, I have a lot of people I can talk to, and I'm not afraid to talk to people. So I will definitely reach out to colleagues or family members and just either have the conversation or not have that conversation, just talk about something else and get my mind off some things for a little while. You've got to make time for yourself. Working from home has been really hard. I'm sure being a student from home is extremely hard. It's hard to walk away sometimes, shut a door, and that's it for today. Sometimes I can find myself working till midnight. I'm like, that's not good. So, I try to make time for myself. I try to make time with, friends or family. I do a lot of reading, yoga, walks, dog. She gives me lots of snuggles. She seems to know when I'm really stressed out. She'll jump on my lap. But, what do we do with our staff is we let them know there's someone available to talk to. We've introduced them to MAP. Your students should know that even as paralegal students, they have access to the members assistance programs a lot through Law Society. It's nothing to do with Law Society. Law Society pays for it, but they're not connected to it in any way. But they have all these free services, and there's workshops, and there's free counseling. You can do it online. You can pick up the phone and call somebody. It could be just that you want to quit smoking. And they'll help you through that. It's a pretty amazing program. and you might as well take advantage of it if you are having issues at all. I suffer from anxiety and panic disorder, so I get too stressed, and then all that sets in, and that's no good for anybody. So, and it's hard to get refocused and something like that happens. But I just make sure I have someone to talk to all the time, or I have those stressors, the relief from my stress, the walks, reading a book, whatever. So that's what I do, but everyone's different. I have a son who deals with the same issues I have, and he won't talk to anybody. So he goes in video games for an hour just to de-stress. So.
Yeah, I mean, I think everyone's different, but it's important, obviously, to take that time, regardless of how you're going to do it. And again, if you can't recharge yourself, how are you going to be able to take care of all your clients and things like that? So thanks for sharing that as well. Now, Michelle, the last maybe question here with respect to, your almost 25 years of practice. And certainly if you were to go back 25 years ago and say, here's what's going to happen. First of all, it's going to be a profession that's regulated. You're going to be involved with the regulation. What can you kind of share in terms of that journey there for my students, in terms of any final words of wisdom as they're going to embark, maybe a 25-year careers for them as well. But what can you share in terms of all of your experience, and what do you think sort of is the future there for paralegals and paralegal education here in Ontario?
Yeah, so I think paralegal education, I think we've got it. I think paralegal education is very good right now. I think there's been a lot of changes over the last several years to make sure that it's very quality education. I think we've achieved that. I think I see the quality of students coming out. My biggest piece of advice, if you're going to graduate and become self-employed right off the bat, and some people do that because they just have the gumption and the ability to do it, and some people are just ready for it, go for it. But make sure you have mentors, a network, someone to lean on, because not only is it a lonely profession if you're on your own, it's there's a lot, like you had just mentioned, there's a lot of stressors. There's deadlines, there's regulation, there's clients screaming at you, and sometimes for no reason, it's just going to happen. So you need to be able to talk to somebody who is either dealing with those types of things or can relate to you, so that you can talk about it, get some advice. Sometimes just to read an email over before you send it to a client, because you want to make sure it doesn't sound too nasty because you're just so fed up with somebody. Just having someone there to do those kind of things. If you're going to get started on your own, even sharing office space, just so there's another body around you that you can vent to if you need to. Even if it's just you in business all by yourself, try to share office space or something. Do something so that you're not completely isolated. Join associations, do your CPDs and so forth. But if you're not, and most people, quite frankly, aren't cut out for that, or they try it and it just doesn't work out for them. Don't be afraid once you get licensed to take an entry-level position. It could be in the mailroom. This is so, passe, everyone talks about it, but get your foot in the door. Sometimes that's what you need to do. If you don't have your own network and own ways to get into a job in the field that you want right away, think of other options. There's lots of companies that have legal departments, like insurance companies and so forth. You can get your foot in the door with them and their legal department. Eventually you can be representing people in court if that's where you want to go, but a lot of paralegals just want to do the administration of stuff too. So try and find a job that's going to work for you. I have one paralegal that works for me. Basically, she just does the research for everybody because she loves it, but she never wants to step foot in a courtroom. So that's fine. You can do that. So you just got to find out what you like and try different things, but don't be afraid to take the job just because it says legal admin. Don't think it's beneath you. Once you get in there and you prove yourself and you show the people that you know what you're doing and you've got what it takes, they're not gonna let your talents be wasted at legal admin. And if they are, it's time to leave. And now you've got some experience on your resume and you've got something to hold on to and move forward.
Perfect. So thank you so much once again for joining us here and sharing all sorts of wonderful advice there about the profession as well as small claims court. I think very succinctly for that 15 minutes there, we've covered pretty much the entirety of the process there, including the difficulties of getting the money in the end, which is also very important.
That's a whole other hour.
So thank you so much, Michelle, for joining us. And thanks everyone for tuning in, and hope to see you again tomorrow at 5:00. We have one of the other program coordinators here and involved at Auxilia Law, which is her firm, Darlene Mezabada. And thanks again for everyone, and take care.
Thanks for having me. Bye now.
Thank you so much, Michelle. Have a great day.
Yeah, thanks. Bye now.
Bye.
Bye.
Thanks, JP. Bye, everyone.